Hello and welcome to NewsClick. Today we have with us Mr. Prabir Purkayastha, editor of NewsClick and the president of Free Software Movement of India, to discuss the Supreme Court's decision today on the Aadhaar. Thank you for joining us. Prabir, on Aadhaar, what in your opinion would be the key takeaways of this decision of the Supreme Court?
Let's go first to the majority judgment. This upholds essentially that for subsidies and for income tax returns, for both of these, Aadhaar has become mandatory. And the argument that this is going to lead to violation of privacy and this therefore constitutes an invasion of our rights, unfortunately has not been upheld by the majority judgment, though the minority judgment has been very clear on this, that this was unconstitutional. The second takeaway from this judgment, good or bad as it might be, is that it has upheld also passing a judgment, this passing of the Aadhaar Act as a money bill. As you know, that we have all argued that the money bill has restricted use and it should really deal with essentially with revenues or the consolidated fund of government's expenditures or incomes if it's being dealt with. Using retrospectively a money bill to pass something as fundamental to Aadhaar has been contested. Unfortunately, that has not been upheld by the Supreme Court. As you know, the Aadhaar never really faced a test in Lok Sabha and Rajya Sabha together, which is what people had argued it should be, because it was actually getting into certain areas well beyond what would be called the budget or tax issues. The third takeaway is that there have been restrictions that have been provided by the majority judgment as well, which has either struck down or read down certain sections of the Act, and they do provide at least certain protection to the people in terms of the possible misuse of our data, particularly by private companies which had been given unfettered right to use Aadhaar by a certain section, the section 57 of the Act, which allowed that all our data could be used for purposes of commerce by either commercial entities or by individuals. Fortunately, this was a completely, shall we say, an overreach of the government, that commercializing our data through a government act, that has been actually struck down. So government entities, yes, they can do it under section 7 of the Act for limited purposes, which is providing benefits and as I said, the income tax, linking the income tax return. But other use of Aadhaar seems to have been at least barred. Now, whether there are loopholes in this or not, which the government will find or the private sector will find, we still have to see. But that seems to have been actually done. And the last part, which I think is also important, is that what information of ours is given to government authorities, that at least we now have a hearing that we can go to and we can represent ourselves. Earlier this was done without our concurrence. And that also, the particular section that was there in the Aadhaar Act has also been read down. So I think some positives in this regard, that it has not opened it to completely everything and anything using our data, but at the same time the basis of the Aadhaar Act and its use by the government still stays. So limited surveillance possibilities, but nevertheless not, shall we say, complete invasion of our rights and privacy. To this extent, we have to say some good, but unfortunately the basis of it still has been retained.
So, Prabir, regarding its passage as a money bill, as far as what I've seen in the majority judgment, it appears that Justice Sikri found that after removing the corporate sector, the private sector from Section 57 and reading it down, then the difficulty in passing it as a money bill was, resolved.
Well, and that is, as I cannot say much about the law. That is not, shall I say, something that I should really speak upon. But it is very strange that either something is a money bill or it's not a money bill. Its use by the private parties is not in consonance with money bill, but its use by government authorities as money bill is in consonance with money bill. This actually, to me, seems very strange. And I think this part of the judgment is in some sense contradictory. Money bill has a specific purpose, and that does not cover how our biometric data should or shouldn't be used. And the fact that it can be used by the government is itself not something which deals with finance or money. So I don't see how that can be a money bill. Just by preventing private parties also to use this provision and make money out of it, that, yes, okay, thank God that, I should, as an atheist, I shouldn't even use that word. But let's say small mercies, yes, that has been struck down. But I still don't see how, even after removing that, it qualifies as a money bill.
And on the issue of, say, private entities that have until now been, had access to Aadhaar and the Aadhaar data, perhaps not directly to the CIDR, but certainly facilitated access to it through the Aadhaar users. So what would their fate be now?
Well, let's first take that, did private sector have direct access to the CIDR or not, which is basically the Aadhaar database. Right. Yes, companies like Airtel did. It's a private entity. And as you know, Airtel made the issuance of, shall we say, SIM cards and accounts, linking our accounts also. They had a provision by which we also apparently opened Airtel bank accounts. And then we also consented the money that we received as subsidy, those who also received gas subsidies, they also transferred that money to the account they had opened without actually informing the subscribers of the telephone number. So that was a gross misuse. And perhaps a misuse like that has also warned the Supreme Court that this needs to be plugged, and that's why this has happened. So the question is, the entire eKYC provisions which are there in this payment gateways, the payment gateways in which banks are involved, the private parties are involved, which would mean that you could use the payment gateways and various other wallets to transfer money to each other, etc. All of this would be happening through the eKYC. And the eKYC would be empowered through Aadhaar. That was the basis of all this. What is the fate of all these activities? I think all these activities now are in the big question mark. I believe it's now, as per the Aadhaar judgment, all of these are now illegal. And therefore the whole ecosystem which was built up on what's called the India stack seems to be at the moment something that under this judgment cannot be allowed to go on. So that's a huge blow to that section of the industry which had been clamoring for all this to be privatized. Essentially, it meant privatization of all our public data, which was being held in public trust by the Aadhaar authority. So I think this privatization of our data has been stopped. And I think that is one part of the judgment which I think has done, at least plugged or done something which needed to be done. Though it has, as I said, it has still kept the basic infrastructure intact.
So, minus the private sector from the entire makeup of Aadhaar, would it then be still possible to say profile citizens, given the data that is held in the repositories, and also the schemes for which citizens require the subsidies they get? Would it still be possible to profile?
Let's put it this way, that you now have databases of all those who have to deal with the government, either in terms of benefits or subsidies, or those who have income tax returns. Now, if we look at this set of people, that's pretty much a major section of your population, which then are being held with the consent of the court. Information is being held with government or government agencies, and if this data is used for different purposes, then yes, a limited amount of profiling of the data is available. Secondly, because there is a PAN card link over there, and a lot of the PAN card link also means that I also have links to my telephone numbers. So to that extent, it does link some of the silos. So the whole argument that the silos remain independent, which is what the majority judgment, Justice Sikri's judgment says, that's really not true. It is not, the silos are not the question of the Aadhaar database. It is the different silos with different agencies who get linked with a common number. So if I breach one secrecy or the protection of one silo through the Aadhaar number, then I can access the other silo, still remain. So I think the part of the argument was not how the Aadhaar database is an independent silo, but using the Aadhaar, you are linking all the external silos. This has not really been understood by the court or has not been accepted by the court. So that extent, the shall we say, the risk to our data was never hacking the Aadhaar database, which has of course been questioned. It's really not hacking the Aadhaar database, it's the linking of the different silos. The only saving grace in this judgment, as I said, it's certain silos are now not mandatorily required to be linked. The question that remains is, most of the people have already linked this. We have linked our bank account, we have linked, most of us have linked also the telephone data. So already the linking has been done. Will all that be purged from the database? That still remains, because if it is not purged, we are at the same risk as we were earlier.
So now in this 5-judge bench decision, there was one lone dissenting judge, Justice Chandrachud, which again in a way brings back memories of another case where there was a lone dissenting judge, which was ADM Jabalpur. So do you think that this would be the next, or say ADM Jabalpur too, where later on, as the years move on, Justice Chandrachud's stand will be vindicated?
Well, it's a very interesting question, because if you see, Puttaswamy judgment, which has led to the Aadhaar case being taken up as a question of privacy, Puttaswamy judgment had also overturned the ADM Jabalpur case 40 years later. And it's also interesting that the current judge, Chandrachud's father, was not a dissenting member of the judgment in ADM Jabalpur case. So yes, I think Justice Khanna, who passed the dissenting judgment in the ADM Jabalpur case, by the way, I was one of the litigants there, because at the time I was being held under visa during the emergency. Justice Khanna had passed that famous dissenting judgment, and later on Justice Chandrachud himself apparently did say that that was a mistake, that the judgment they had passed, and this is what was rectified recently in the Puttaswamy case, when the court said that that was a mistake that has been done. I think if we look at where technology is going, the risks of technology, I think this will be something which in the next 10, 15, 20 years is going to be so apparent that this was a bad judgment, that what we are doing is allowing technological uses to invade our various aspects of our life. And this is something which needs to be regulated, stopped, that from happening. Is something we're going to get with not only governments, but we're also probably going to get with companies like Google and Facebook, which are doing privately what the government was supposed to be doing here. And as you know, government was supposed to do this in favor of Indian big capital and use public funds for doing all of this. This was the intent of the 57 sections saying body corporates and private individuals. This is really the intent of it. I think we will revisit this, and certainly in much less number of years than happened in the ADM Jabalpur case. The ADM Jabalpur case, as you know, was really immunized later on in the parliament. But I think, yes, as a judicial pronouncement, this will need to be either addressed in future by the parliament or by another Supreme Court bench. That this is something that has opened us to a lot of possibilities, none of good for us.
Well, thank you, Prabir, and thank you for watching NewsClick.